Hey, notice of removal. Although you can really take care of most of the situations in any lower courts if you really know what you're doing, but oftentimes you will find that it's reasonable for you to remove it. So instead of waiting to first get that initial case dismissed and then bring in a claim, there's something called a counterclaim. And the way a counterclaim is done is through a notice of removal. A counterclaim is basically any other situations or any other claims that come up out of a circumstance that someone else is bringing against you. In other words, a counterclaim is basically, think of it like a counterpunch or counterkick or counterattack within any type of martial arts. If someone punches you or kicks you, you would do a counter to that. What a counterclaim is an offensive move. It takes you from being a defendant to a position of a plaintiff. So now whoever is initially suing you plus whoever might have caused you damage in the process of that other party bringing claim against you will now be a defendant, whereby you're a plaintiff. And that is laid out in all throughout federal rules of civic procedure and your state rules of civic procedure. If you were to go to federal jurisdiction, if you were to remove it, if you don't want to remove it to a higher state court, if you want to remove it to a federal court, it's in Rule 13 of Federal Rules of Civic Procedure that governs counterclaim. It says a pleadant must state as a counterclaim any claim that at the time of its service, meaning you will have to deal with it just like you do a regular complaint if there was no other issues involved. You have to serve them a summons, but in this case the summons will be the notice of removal, and in some cases you have to do a summons also. The pleader has against an opposing party if the claim arises out of the transaction or occurrence that is the subject matter of the opposing party's claim. Meaning whatever the opposing party is saying you've done, if another subject matter arose out of that, for instance, say you were arrested for supposed aggravated assault, and in the process of that the municipal employee actually battered you and engaged in assault and make statements like, well, look at the way you look at the way you're dressed, look at the way you speak, you're speaking a different language, I don't feel comfortable with that, I have to do this with you and do that. Out of that, there was no search warrant, they searched you, they didn't articulate the suspicion of a crime to you, because they have to invoke that. There has to be a reasonable expectation that a crime was committed, is being committed, or is about to be committed, for them to invoke a frisk or a Terry stop, or for them to begin to even come close to an exigent circumstance. And they didn't do any of that. They just received the call and they just came up there all hyped, because most of these municipal police are always in a heightened state, and it's a culture for them to be like that, because, well, money is made much more easier when people are in a state of fear. Emotional trauma and stimulation of the emotions is very good for economics and money. So say they just come in there heightened and they just railroaded you, and as a result of that, your due process, your right to be served a warrant, the existence of a crime, a lot of things, unusual punishment, right to association, all of that came up. And then at the end, they sued you in a court saying, yeah, well, we received a phone call from somebody that says that this guy attacked someone, so that's why we had to go up there and treat him the way we did, and now we're bringing him in court. Well, what you will do in that situation is a counterclaim, because your claim will arise out of the occurrence that is the subject matter of the opposing party's claim. Even if it's something like a traffic ticket, if due process was violated, you can do a counterclaim. And how you do that is this. It's within 28 USC 1441. It's called in summary, it's called a notice of removal. You make a plain statement so that they don't do a 12b6 on you. Just make it very simple, 2-3 sentence. This case heading blah 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 is hereby removed, to name the name of the other court that you're removing it to. If it's a federal court, name the name of the district court. Or claims arising out of, you can use this verbiage or not, and then you put that on the docket, and you send it to the opposing party and whoever else is the new party that you're joining, and you do a regular summon for them. Then you take all the documents within the docket of that old case within the state court, everything from the beginning to the end, including the disposition. You take it and you add it exhibit onto the removal notice. That is very important because you have to show that new court that you're removing it to that, okay, this is the situation at hand. Otherwise, if all they see is your counterclaim and a notice of removal, they're thinking, okay, where is the situation that your claim arose out of? They have to see it. That's how that works. But nonetheless, it's in 28 U.S.C. 1441. It says, except as otherwise expressly provided by Act of Congress, any civil action brought in state court of which the District Court of the United States have original jurisdiction may be removed by defendant or the defendants to the District Court of the United States for the district and division embracing the place where such action is pending. How does the District Court of the United States have original jurisdiction? They let you know. Based on diversity of citizenship, that's one. Based on the amount, if it's at least $75,000 amount of damages that you're claiming from your counterclaim. Or three, if there's a federal question. And the good part is, oftentimes the substantive rights that's secured within your state constitution, there are synonymous verbiage within the federal versions. So if it's due process you're looking at, if it's warrant, all that, if it's right to association, right to bear arms, it's in the federal also. So once you invoke any federal laws, then the jurisdiction goes with it automatically. So those are the three ways that the district court can have original jurisdiction. And in some cases, if you bring in state laws whereby there's no equivalent version on the federal level, then they will call that subsequent jurisdiction. And once the federal issue has been dealt with, they will remand the subsequent issue back to the state court. Not because they're denying you there, but just because they don't have jurisdiction over it, because there's no equivalence on a federal level, or you've yet to invoke equivalence on a federal level. So they're going to remand it back to state court to make decisions for it. So that's basically what this is really saying, but the deeper explanation is this. Removal based on diversity of citizenship, which is one of the ways. In determining whether a civil action is removable on the basis of the jurisdiction under 1332A of this title, the citizenship of the defendant sued under fictitious name shall be disregarded, meaning entities that are not natural persons. Legal fictions can be sued also. Civil action otherwise removable solely on the basis of the jurisdiction under 1332A of this title may not be removed if any of the parties in interest properly joined and served through by letting them know that there's a notice of removal to the court, the lower courts, and to the other party that you are pulling to the federal court or the other higher state court. And then, of course, a summons to them as defendants is a citizen of the state in which such action is brought. So, in other words, it's telling you you have to be of different citizenship status. Different citizenship status. It can be of someone from a different state, or it can be based on your nationality, one way or the other. And just to look at 1332, it basically really summarizes the same thing. Diversity of citizenship, amount of controversy, which is the third one. It says, the district court shall have original jurisdiction of all civil actions where the matter and the controversy exceeds the sum value of $75,000. There you go. That's the third way. The amount, the diversity of citizenship, and federal question. Exclusive of interest and costs, and is in between citizen of different states, diversity of citizenship. Keep in mind, this word state can really just mean different entities in some cases. It doesn't necessarily have to be different, state of Iowa and the other party from state of Texas or state of New York, etc. Citizens of a state and citizens or subjects of a foreign state, except that the district court shall not have original jurisdiction under this subsection of an action between citizens of a state and a citizen or subject of a foreign state who are lawfully admitted for permanent residence in the United States and are domiciled in the same state, regardless of whether you are here as an employee or not. So long as you're in the same state, we don't have jurisdiction. It has to be a true diversity of citizenship if that is what you're claiming. But even if the parties that that originally sued you, that you're doing a counter to, is from that same state, you're still qualified based on the amount and federal question. Foreign state, defined in 1603 of this title as plaintiff and citizen of a state or of a different state. Well, 1603. Foreign state, except as used in 1608, includes political subdivision of a foreign state or an agency or instrumentality of a foreign state, as defined in subsection B. Agency or instrumentality of the foreign state means any which separate legal persons, corporation, otherwise. There you go. The entities are just different, who owes different status. Then it tells you how to join them. A claim arising under the Constitution, laws, or treaty of the United States. Meaning this is the third way, a federal question. If you have a question that that arises based on the Constitution of the federal jurisdiction or any treaties, keep that in mind. Then they have jurisdiction. Joinder means they have jurisdiction. So those are the three main ways. Now read this section so you can just get a better and deeper understanding of it. There's one more that's very important. The amount of time. You have 30 days to remove it. Now, if you don't remove it within 30 days, they give you a vague opening, meaning you can, so long as you have a reasonable cause to say, okay, I didn't remove it within the first 30 days. So after the first 30 days, I'm removing it because of this. If it's reasonable, then you can do it. But nonetheless, the general outline is 30 days. Generally, a defendant or defendants desiring to remove any civil action from state court shall file in the District Court of the United States for the district and division within which such action is pending a notice of removal signed pursuant to Rule 11 of Federal Rules of Civic Procedure. So you have to understand this, because this is the rules that they use as operation of their parliamentary procedures within the federal court. Do a notice of removal, add it to that state record, and then take everything on their docket, add it to that same notice of removal, and open a counterclaim on a federal level, and then send a notice of removal to the respective parties that you are making that counterclaim against. Pursuant to Rule 11 of Federal Rules of Civic Procedure, containing a short and plain statement of the grounds for removal. Don't be long-winded. Together with a copy of all process, there you go, see, together with a copy of all process, pleadings, and orders served upon such defendants or defendants in such action. Requirements. Generally, the notice of removal of a civil action or proceeding shall be filed within 30 days. Remember, generally, meaning it's twofold. Just like there's general law and special law, when you see this word generally, there's always an obverse, which is there can be special circumstances. It has to be a very good one. But nonetheless, the notice of removal of a civil action or proceeding shall be filed within 30 days after the receipt of the defendant through service or otherwise. If it's a traffic ticket, they have served you a summons the moment they hand you that ticket. That's you being sued right in the middle of the street. And sometimes they don't even serve you summons in criminal cases because they don't want you to remove it. And that could be part of your affirmative defense as a special circumstance as to why you haven't removed that outside of 30 days. Lack of service or process. That will be part of your counterclaim if you want it to be. But there are way more stronger causes beyond that. But just, you can come up with it if it really applies and it's reasonable. So nonetheless, you have 30 days after the receipt of the defendant through service or otherwise. See? Or otherwise, meaning there are many other ways they can join you. Of a copy of the initial pleading, setting forth the claim for relief upon which such action or proceeding is based, the complaint. Or within 30 days after the service of summons. Usually the summonses are built out of the complaint. Upon the defendant of such initial pleading has then been filed in court and is not required to be served on the defendant, whichever period is shorter. So it goes on to say, when a civil action is removed solely under section 1441A, federal question. All defendants who have been properly joined and served must join in or consent to the removal of the action. Meaning if there's more than one defendant, and if more than one man or woman were in the same case and you guys were defendants, all the other guys must consent to it. And usually it's just one affidavit that says, yes, we accept this, or we hereby, join the removal, or blah, blah, whatever it is, however you want to say it, just make reference to the removal and show that you consent to it. It's that simple. If there are more than one defendant. Then it goes on to say, and that is if you are all properly joined. Each defendant have 30 days after receipt by or service on that defendant of the initial pleadings or summons described in paragraph 1 to file notice of removal. So all these other guys, if there's more than one defendant, they all also have to file a notice of removal too, or consent to it. If defendants are served at different times and a later served defendant files a notice of removal, any earlier served defendant may consent to the removal even though that earlier served defendant did not previously initiate or consent to the removal. And in some situation you will realize that they amend their complaints. So whenever they amend their complaints, even if they amended their complaint 90 days, 100 days after they initially sued you in the state court, that amended complaint basically resets the time. And it's telling you, except as provided under subsection C, which is requirement removal based on diversity of citizenship, if the case stated by the initial pleading is not removable, and if for whatever reason you have somehow been disqualified from being able to remove it, a notice of removal may be filed within 30 days after receipt by the defendant through service or otherwise of a copy of an amended pleading, motion, order, or other papers from which it may first be ascertained that the case is one which is or has been removable. There's another loophole, that's a certain special circumstance. Requirements removal based on diversity of citizenship. The case may not be removed under section B3 on the basis of jurisdiction conferred by 1332 more than 1 year after commencement of the action, unless the district court finds that the plaintiff has acted in bad faith in order to prevent a defendant from removing the case. Here's another thing you have to prove. I have to prove that whoever it is that is suing you or you guys have basically done things in bad faith to prevent you from being able to exercise the operation of law, which is the removal of any case. And you have 1 year to do that. That is another exception to the 30-day limitation. And the section 1332 it makes reference to here is diversity of citizenship. So read it. Basically just tell you that the three main ways that you can qualify to remove a case to a federal jurisdiction is if there's diversity of citizenship, the legal entity or the natural man, if the amount is at least $75,000, or if there's a federal question in the issue, which is basically the conditions for you to be able to remove it. So there's an exception to the 30 days. If there's bad faith and they've willingly and knowingly prevented you from being able to remove it and enforce substantive right to move the case, or if there are any other special circumstance, or if the case has been amended one way or the other, then you can remove it. Or if you were not properly served and you weren't aware that a case was going on, then the first time you were able to realize that, oh wait, hold on, there's a case going on here. All right, well, I'm removing it. And here it is right here. The papers from which it may first be ascertained that the case is one which is removable. Then the first moment where you realize that it's removable, based on the fact that you weren't properly served, properly joined, you can bring up that claim too. And then there's more. And then it goes on to the fact that you can either make monetary damages claim or not. But nonetheless, those are the 4 main ways. 5, shall I say. First, you need a counterclaim to qualify for removal. So in other words, you better know what you're doing about how to construct a claim and how to come at them. Or else they're going to throw judicial immunity, qualified immunity, 12b6, all that. They're going to come at you. They're going to throw a motion to dismiss, all that crap. So know how to really formulate a suit, because a counterclaim is you suing them. 2 is do a notice of removal, put it on the case, send it to the whoever is suing you and whoever else you realize need to be sued, and send them a notice, a summons also, and take that notice of removal, send it to the whatever court you're removing it to, and take everything regarding the old case where the new claim arose out of, where they sued you, take it as exhibits and attach it to that notice of removal along with your counterclaim. And 3, make sure that there's either a diversity of citizenship, or the amount of damages you're claiming is at least $75K, or that there's a federal question, meaning you're making a constitutional claim. Constitution is secured right. They're in the federal constitution. Is there more? Yes, but here's a reference for you. You got it. Read it. Best of luck. Godspeed. Now, after all that happens, and say the outcome is not in your favor, and there was a newfound evidence that you ought to have brought in that you didn't, or there was an error that you did in fact objected to and took exception to, and you denied on record, then you can do an appeal, because an appeal cannot look at new evidence other than the ones that you were not aware of, and there's a reasonable expectation that you could not have been aware of it at that point, and you can bring it back up. Aside from that, appeals cannot look at new evidence. Appeal only look at everything that already happened within any given case, and then realize, okay, and then make a decision, okay, did that magistrate or judge really apply the law properly? If not, then we're going to reverse it. And oftentimes appeals take eternities. So appeals apply when you've gotten your ass kicked and you're trying to change it.